Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
If he's not already.
Okay, Ms. Jones, can you hear us?
Yes.
Okay. All right, well, let's get started. Ms. Rivers, let's handle the arraignment piece first. So Ms. Jones, I'm Judge McBurney. We haven't met before. Your lawyer, Mr. Luemba, is on the screen, the gentleman with the glasses with the yellow lenses. He's representing you in this case. A prosecutor is in the courtroom. I don't know that he'll be handling the case forever and ever, but he's certainly handling it today. He is on one of those screens. And then Ms. Singleton, have you and Ms. Jones met before? Yeah. Okay, you know Ms. Singleton. Okay, yeah. She's here as well. And we're going to do a couple things today, Ms. Jones. One, we're going to handle your arraignment, which is an opportunity for you to enter a plea of guilty or not guilty, waive arraignment, etc. And then I think we're going to talk a little bit about bond. But let's handle the arraignment piece first. Mr. Luemba, did you already file a waiver or do you plan on filing a waiver?
No, we're just going to waive on the record, Judge. We're going to waive formal arraignment, plead not guilty. And I'm not going to request 10 days to file a motion pending discovery. I don't know how voluminous it is. I may need more than 10 days. So request some significant amount of time to file motions after receiving discovery. But we will be waiving formal arraignment and pleading not guilty.
Okay, couple things. One, I'm going to have you fill out the waiver form. I know it's sort of on the record, although I didn't ask you to take down the start yet, but so we can get it in the docket, I'll have you file the waiver form before you go. And then we'll get a scheduling order in place. I may have a deadline for motions, but that's going to be flexible. It will be after discovery is delivered. Mr. Heil sent an email out to all the lawyers. I think you were on it that said, please deliver a hard drive.
We did.
You've done that. Okay, good. I'm going to be sending a spreadsheet out to all the lawyers saying, here's my list. I think these are the lawyers involved. And then I need to know who's received their hard drive yet, because really it doesn't make sense to start imposing a motions deadline until everyone got the hard drive. And then it probably will behoove you all to talk with one of the prosecutors to say it's 6 terabytes. Where would one start looking? And you're entitled to many more things than you might need to figure out, is there a motion to suppress in here? There may be, I'm making this up, 18 cell phone extractions. But really, the question about suppression would be, was my client's phone taken and what were the circumstances of that? That might be one police report. And so instead of being overwhelmed by a terabyte of data, it would be, what's the basis for having acquired my client's cell phone, that kind of thing. So I'm hopeful that there will be an exchange between the defense attorneys and a prosecutor. It's made a little complicated by the fact that Mr. Hiles, whose case this will be in the long run, is on break for a little while. Right. I know Mr. Abadi is helping out. There was a Mr. Smith here earlier as well. But I'm going to rely on the lawyers on the defense side to let me know if they're running into everyone is saying, it's not my answer. I don't know how to answer that, because we may need to have a discovery conference just so that this isn't a case that takes a year just for people to get through discovery.
Right.
Okay. But your hard drive is in the queue. That's all you can do for right now. You had filed a bond motion. Mr. Abadi, I don't know that the calendar doesn't say anything about bond, but I know earlier today you heard Mr. Luemba say he was hoping to talk about bond. Are you in a position to have that conversation?
Yes.
Okay, then let's get on the record. Ms. Rivers, are you good to go?
Yes, I am.
Excellent. So, Ms. Jones, this is case 25 SC 006076. You are indicted with many others in the case. You have some pretty serious charges in the indictment. Mr. Luemba is going to talk to me about why you should have a bond, what that bond should look like, meaning dollar amount, what the conditions should be, et cetera. Then I'm going to hear from Mr. Abadi, who is one of the prosecutors on the case. I may also hear from members of the victim's family. They're entitled to be heard in a setting like this. They don't have to say anything at all, but if they want to, then I will certainly be listening to them. And then I will let you know what I'm going to do about bond in your case. Okay?
Yes, Your Honor.
All right, Mr. Luemba, when you're ready.
Yes, Judge. And again, we got this case and not seeing discovery, but with the little bit I know about it, I know that Miss Jones is 16 years old. It's our position, is going to be our position moving forward, that she's actually a victim of coercion, intimidation, and duress in this particular case, Judge. This happened when she was 16, a student at Doug High School, a student from all accounts that was in AP, advanced placement classes. This is someone that worked. This is someone that you will see on the record, I'm sure the state will concur, has absolutely no criminal history, never gotten in trouble with the law before, no juvenile. There's no history of, from what we've seen from talking to Doug High School, of disorderly conduct or fighting or things of that nature. And we believe that just based on that alone, and the fact that she meets all of the Ayala factors, not a flight risk, significant ties to the community, not a danger to persons or property in the community. She won't intimidate witnesses. And she's not if past behavior is indicative of future behavior, she's not someone that's a danger to commit future felonies, Judge. As the court indicated a little bit earlier about her being placed so far from Atlanta, and we don't know why, but a lot of times when people are separated, it's because they could potentially be maybe victimized. This is another going back to what our potential defense would be, that she is actually a victim of coercion, intimidation, and duress from all these other people that she is charged with, Judge, who I believe are actually the most culpable. I can't even believe she's sitting here, to tell you the truth, Judge. And so because of that, we would ask for a reasonable bond not to exceed $35,000. Mom is a single mom. I've had several conversations with mom. I know mom could potentially afford $35,000. And this is a young lady who, because her grades were so good in school, and she's somebody that could actually get back in school and get back on that right track that she was on prior to being caught up with these negative influences who are currently co-defendants.
Okay. You name the high school several times as Doug High School. Where is Doug High
It's in
School?
Atlanta. It's in Atlanta.
Okay.
Yeah.
Douglas. Oh, Douglas. Okay. I'm familiar with Douglas. I wasn't sure if maybe it was a charter school.
Douglas.
Okay. Douglas High School. All right. I appreciate you sharing all that. Ms. Singleton, I'd like to hear from you what you know about Ms. Jones, to include any juvenile history. Mr. Luemba is saying there's none. There shouldn't be any adult history for her, but if you could share what you've got, please.
Yes, Your Honor. As Mr. Luemba stated, she has no prior juvenile history. Unique has been an honor student since pre-K. Her mother had actually provided multiple certificates that she has walked through the years. This morning, I had her just take pictures and send me pictures of them. She has over 25 plus certificates from pre-K on for the national. She's a member of the National Honor Society. She's a AB honor roll and A honor roll. She had multiple principal awards, science awards, Spanish, music, math awards, multiple citizenship awards. She was in the National Junior Beta Club. She was Miss Fifth Grade. She has excelled academically her entire school career. She actually was dual enrolled at Douglas and Atlanta Metropolitan to be in the, I believe it was the dentistry program. And she also has participated in flag football and was expected to graduate early in December into this December, actually. However, she is incarcerated. She's also had several jobs. She's worked at Chick-fil-A, Taco Bell, Popeyes, and Pizza Hut. Her mother and I have spoken about if she were to be granted a bond, where she would live. Her mother has provided 2 addresses that are in Metro Atlanta, and I can provide them to the court if needed, and when needed, in Metro Atlanta, but not in the Atlanta downtown area with grandparents. One address for grandfather with his wife, and there's a 21-year-old grandson in that home. Another address with grandmother, and there is an adult cousin that lives there who is a Clayton County police officer. So she could live at either one of those residents. If she were granted a bond, she would be under my supervision. She would receive the county-funded ankle monitor. If the court ordered an ankle monitoring with all of the standard bond conditions, no social media, no weapons, no contact with any of her co-defendants. I believe that is all that I have, Your Honor. Yes, at this time, that's all I have.
Okay. Have you spoken with either grandparent or you spoken with mom who assures you that either of those households would be open to having Ms. Jones?
I've spoken with mom.
Okay. Ms. Jones was arrested in May, mid-May. Did she get to finish? I guess that's not quite finishing whatever school year she was in. So is
I
she?
believe it was March the 2nd.
Oh, I have her booked in May 16th.
That's in the Fulton County Jail.
Okay.
She was at Metro on March the 2nd.
Okay, so she's been in since March, so 8 months now.
Yes.
Okay, so she missed a chunk of whatever year she was in when arrested. And if she is taking classes now, obviously it's at a YDC or she's in Spalding. I don't know what she's doing for school now, but.
Correct, Your Honor. So academically,
It's a life interrupted.
yeah, life interrupted. She may be able to get back into school just based on something I recently, yesterday, had happen on another case that would be in the area that she would potentially live at. She may actually be able to get back into traditional school. If not, then I would probably suggest looking at a GED program, which she should probably be able to get in record-breaking speed.
Okay. All right. That is helpful. Of course, Ms. Jones, your life has been interrupted. It's in connection with a life that was taken. I just looked at the indictment and realized you're charged in the murder of Mr. Smart, not Mr. Van Arsdale. They're two different murders. I knew they were two different murders. I thought you were with the defendants who are accused of shooting and killing Mr. Van Arsdale, but you are with one of the defendants is involved with both, Mr. Bird. The murder of Mr. Smart. So, Mr. Abadi, I would like to hear from you, your thoughts about bond and a little bit of context. You know, the struggle I had when working with Mr. Hiles was trying to sort out, in particular on the Van Arsdale side, there are 5 or 6 people who are charged with killing Mr. Van Arsdale. And that means probably different roles that people had. Party to a crime is out there, but it helps me understand not that these are the facts of the case, Mr. Luemba, but the state's theory of how does someone plug in? If this was the person who had the gun that killed the person, as opposed to it was the getaway driver. Or I'm making this up, but if you could help orient me a little bit to the state's theory of Ms. Jones's connection to what she's charged with. And then I know there's at least one person online who wants to be heard. So it may be that Mr. Smart's family is more online than here in person, but either way, I will hear from anyone who, don't worry, I'm not going to cut any corners. So, but I'm going to start with you.
Yes, Judge. Is it okay if I start with the procedural history?
Yeah, please.
Because as it relates to Ms. Jones, bond was heard before Superior Court Judge Rochelle Carnicel back on I think it was May 13th of this year, after hearing all of the information provided by the state, as well as her counsel. She denied bond, finding that Ms. Jones was a flight risk and a risk to the community and the people in it, based on the presentation that was presented back in May. Based on the information that Mr. Luemba is presenting to the court today, there's been absolutely no change in circumstances articulated to this court that would warrant a change in Ms. Jones's bond status. As it relates to kind of the factual circumstances of this case, Your Honor, what I would say to the court, and I don't really know any other way to say it other than very bluntly, if Ms. Jones was not involved, Mr. Smart would be alive. She is the direct reason that Mr. Smart is dead. She picked him, she identified him, she lured him to the location, knowing that her boyfriend, Mr. Few, and his friend, Mr. Bird, had planned to not only rob him, but shoot and kill him.
So the luring too is to an armed robbery that either she should expect was going to be fatal, or according to the state's theory, knew that Few and Bird, they didn't leave their victims alive. They were going to take what they were going to take, and that victim wasn't going to walk away from it.
Correct. She was privy to a conversation after she identified him, that after identifying that it was Mr. Smart, that he would be somebody who would likely buck. And then both Mr. Bird and Mr. Few said, then he's got to die. And she still continued to lure, and she was the attraction to the Gun Club Road for an alleged marijuana exchange.
Okay, so Smart was identified not because he was a rival gang member, but because he was a mark. Was he going to be buying marijuana or supplying marijuana?
Supplying.
Okay, so for whatever reason, Ms. Jones thought he would be a good supplier, have money, drugs on him, something, and that's the connection.
She identified him because he would be an easy mark that would be profitable.
Okay.
And she then went with Mr. Few and Bird to the location, the 1200 Gun Club Road, continued to FaceTime and communicate through text message with Mr. Smart, getting, all the directions he should take in order to make sure that the sale was successful. And at that point, she's also simultaneously communicating with her two co-defendants, describing his vehicle, how to get into his vehicle, things of that nature, to which they then ambushed and killed him. Miss Jones then left the location with both the defendants and went back to Mr. Few's house. And I can tell you the videos do not show that she was being coerced or she was under any sort of duress. She's giggling, laughing, playing with guns and marijuana with Mr. Few. So she may have had a very promising future prior to this, but she is very, very much responsible for the current situation that she's in based on all the facts and the evidence. I would also bring to the court's attention, she may have been a great student, but at this time she had been declared truant out of school. She had stopped attending. And my understanding is that—
Hold on 1 second. Yes?
I don't know what the background noise is, but someone's mic is open.
Okay, well, I'm going to do is mute Deputy Max, because I think it's probably something that they can't control there, and then we'll unmute when it's time to hear back from Ms. Jones. Ms. Jones, wave your hand if you can still hear us. Okay, good. So we'll press on. I think that should fix it, Ms. Rivers. If it doesn't, let me know.
Okay, thank you.
You bet. All right, so you had mentioned that at the time of the shooting, that Ms. Jones had taken herself out of school.
She had stopped attending.
Okay.
She had decided to, I guess, replace her time at school to hang out with Mr. Few, who was a member of this gang. I think they go by several different names. But
Got the number 4 in it.
4 Life or 4 is one of them. It's a part of the, I call them the Glizzy Bears, but it's the Glizzy gang.
Okay.
So based upon all of that, Your Honor, I would strongly oppose bond in this case as it relates to Ms. Jones at this time. As the court is aware, and I believe Ms. Cabrera just sent an email that confirming that the USB drive or the large terabyte drive was dropped off. So we'll have that as soon as it's ready.
Okay, well, that was Ms. Cabrera represents someone different, but Mr. Luemba said he's dropped his hard drive off. So
This morning.
I always think you guys work together.
That's okay.
Yeah, just
Right, but they're sufficiently separate that it's okay that Mr. Luemba has
sure.
one. Yeah. Just so we're clear. But Mr. Luemba's hard drive was dropped off this morning, and I know there are paralegals or whatever the right title is who are busy loading up those hard drives.
And then Mr. Smart's mother is on Zoom. She'd like to make a statement, as well as other members of Mr. Smart's family who are here in person who'd like to address the court.
Okay, and I would like to hear from all of them. I just want to find one thing first. Okay. Tell me who is going to go first, and we need their name so Ms. Rivers can make a record of that. Someone who's online, there've been people online for a while. Why don't we do that? iPhone 281.
I believe that's Mrs. Smart.
Okay, but we got to stop because Mac dropped off again. There's a deputy seat, different phone. All right.
Yes, Judge, we have to switch phones to have a better connection.
Okay.
It's going to be on Spalding County Network.
Okay.
This is Deputy Taylor with Spalding County. That's my phone.
Thank you, Deputy Taylor. All right, Ms. Jones, can you hear us? Yes. Okay. Ma'am, iPhone 281, can you please give me your name?
My name is Dion Ewing.
Okay. And tell me your connection to Mr. Smart.
Alexander Smart was my son.
Okay. So your mom.
I am. I was
All right.
anyway.
Well, I'm sorry for your loss, and I would like to hear from you, your thoughts about bond. That's what we're limiting ourselves to today, bond and Ms. Jones.
Bond, I am totally against bond. Had Miss Jones not given my son as the willing participant victim that she knew that they were going to kill, he would still be alive. The two never knew my son. She is the only one who knew him and gave him up. She participated and lured him by calling him all day to make sure he was going to arrive at the point. When she knew the others got arrested, she fled and was the last one to be arrested. She fled for a month. My son has a daughter who will never see him again. I will never hear my son again. We are a close-knit family. We will never hear him again. He was the glue to our family. He was the most loving person of our family and gave back to the community. And I am 100% against her having any freedoms to a bond, as my son has no freedom to life.
All right. I appreciate you sharing that. What was your understanding as to how your son knew Ms. Jones?
My son sold marijuana only by, apparently he was a chauffeur and she was his regular marijuana customer.
Okay. So they had I'll call it a business connection.
Correct.
Okay. Well, ma'am, again, I'm sorry for your loss. There's not a way to recover from that, but hopefully you are seeing that the case in which your son is a victim is moving forward. The district attorney's office is doing what it can, and we are lining up lawyers for each of the people who have been accused of being complicit in your son's murder. The case will stay with me. A victim advocate will let you know each time there is a court proceeding. You are welcome for any of them. We always live stream it, so you'll be able to follow if you look like you work at a hospital or something. So if you can't be here in person, you can follow it. But you're also always welcome to be here in person. And I appreciate your time.
Thank you.
Okay. All right. Next, if anyone.
Her name is Miss Melinda Davis.
All right, Ms. Davis, if you'd come on up, I'm gonna have you sit next to Mr. Abadi, please.
State his name for the record.
Hi.
Melinda Davis.
Hi, Ms. Davis.
I'm the girlfriend, / baby mother to the defendant, but I just feel like she don't
To
deserve.
Mr. Smart. You were Mr. Smart's girlfriend and you and Mr. Smart had a kid,
Yes, we have
Got
a
it.
daughter together.
a daughter. What's your daughter's name?
A more smart.
And how old is she?
She's 2 now.
Okay, and you're taking care of her
Yes. by
and you
myself.
don't have Mr. Smart to help.
No, I do not.
Okay.
And then I just feel like she don't need to get off because it's kind of hard knowing that if she get off, it's like I still have to constantly deal with it because her family stay out there with me. And that's not going to,
Meaning Ms. Jones's family is out near you.
yes,
Okay. Do they talk to you at all about this?
no.
Okay, but it's awkward being near them anyway.
Awkward being in the same
Sure.
place as them.
Now you understand that if Ms. Jones did get bond, she would be staying not in the place you're describing.
No.
You don't understand. I'm telling you that if she did get a bond, she would not be staying in your community.
Hope not.
Okay, good. All
I
right.
hope not. But no, I don't think she should, because it's hard on my end, because my 2-year-old daughter, she knows her daddy. She knows who he is, and I have to deal with this every day. She asks about him. She have bad dreams about him. I have bad dreams about him. And I shouldn't have to go through that, and neither should my daughter.
Yeah.
Y'all did what y'all did, and you didn't have to do that. You didn't have to give him up and set him up like that. That was wrong of you.
I need you to talk to me, okay? There'll be a time later to talk with Ms.
I'm
Jones.
just talking out loud, but I'm
All
not
right.
directly talking to her.
Got it. And I need you to pause for a second because we lost our Spalding County connection again. But I'm feeling you. I understand what you're saying, but talk to me, okay? Let's wait for them to come back on. Is your sense it's a bad connection or their phones keep dying? Bad connection. And it's just too much of a pain to get her out into the van? Or Spalding County doesn't have cell service? Okay.
Might be in jail.
It is. Looks like Deputy Taylor is back on. Just need him to power it up. There he is. All right, we're back on. We paused once I saw you drop off, Ms. Jones. Ms. Davis, was there more you wanted to share? I have a question, and then you can add whatever you want. Tell me how you're making things work. Are you employed? Are you in school?
I am working 2 jobs as of right now, but I had to quit one because I still have to focus on my child.
Sure.
And make sure that I have enough time, to get her from daycare and all that.
Yep. Do you have other family members who are able to help?
A little bit.
Little bit.
But it's not a guarantee.
No.
So,
It's your kid,
yeah.
right? Okay,
Yeah,
I understand.
She's mine.
Yep, I have a few too. So, well, I appreciate that you're staying focused on her. And I'm sorry that there is this pain and awkwardness when she says, "Where's Dad?" I mean, you're just there's not a happy answer to that.
Breaks me because she do it when he was here.
Yeah.
She used to just go, sit at the door, wait on him. She still do it now.
Yeah.
And it breaks my heart that she would never see her dad again, get to hear his voice, calling her big girl, stuff like that.
Yep.
He missed her daughter, her father-daughter dance, the best moment of her life.
Mhm.
And that broke me. Like, I have to deal with a lot.
You do, and you'll have to keep doing it because she's going to turn 3 and 4 and 5, and Dad's not going to be there.
Yeah, as for him to this day,
Yeah. Okay. Anything else?
no.
All right. I appreciate you being here. I know this is not easy to talk about.
It really not come.
Okay.
Trying to hold it together.
You're doing a good job. Thank you.
Thank you.
Okay.
I think it's Mr. Smart's sister. I could be wrong.
We'll find out in a second. Good morning.
Good morning,
Tell me who you are, please.
Amanda Smart.
Okay. And your connection to Mr. Smart,
That's my little brother.
your little brother. Okay. What do you want me to hear?
I think just after listening to the defense lawyer, I just wanted to make it really clear that you can have all the best grades in the world, but it's about the environment and the way that you live. And I feel like just based off of the things that we've heard thus far and the fact that her and her family supported her while she was a flight risk initially, and then coming back and just hearing even the support around, there's very little accountability to what has happened, trying to villainize my brother in a way that, yes, he sold weed, but he never tried to kill anyone. He was never aggressive. My brother is by far the most emotional, caring person that I've ever met, more emotional than me, and I'm even in this state right now. So just to bear witness to this assassination of my brother's character, and just to see how little they cared about my brother and how little her family cared about what they left us with. I don't think that even if she got out on bail, that they would even support true justice. I think if they had the means to, they would do whatever it took to, if they could get her away again, maybe they could. And just to see, to spend that amount of time waiting for them to figure out even who did it, because we actually thought that there might have been a closer relationship to who would want to kill my brother, and to know that he was just a person that fit the bill. I think that trauma and that paranoia to my family again would just be devastating. And if it ended up aligning to someone else, like to know that the court would have to know that they're capable of doing these things,
Right.
if we allowed somebody who could go to sleep at night knowing that they would just volunteer another person to die. So.
Okay. Well, I appreciate you sharing that. And my opinion in this process doesn't matter a whole lot. It'll be a jury, it'll be lawyers who are negotiating, but I do want to put your mind at ease on one thing, and that's that your brother's life was not worth any less because he may have sold some marijuana. That doesn't trouble me in any way. I don't think, oh, I have to value bonds differently. I asked the prosecutor and the defense attorney questions because it's a different case if people were shooting at each other and it's self-defense. And defenses will evolve in this case, and I have very, very little information. But you lost a brother. That's what matters. And if he sold washing machines or he sold marijuana, it doesn't mean that he should suffer the fate that he did. So I think you are seeing that the justice system isn't devaluing him. Oh, that's not a serious case, we won't do it. They've indicted the case. It's a big case. It's actually put together 2 different murders that are connected through Mr. Byrd and allegedly this gang. And so you should know that no one, at least in the criminal justice process, is viewing this as, oh, it's less important because Mr. Smart may have sold marijuana. Maybe he did, maybe he didn't. None of that is a license to, okay, then we can kill him and take his money or his product. So I'm not hearing anything that is demeaning to your brother. I'm hearing you and his girlfriend and his mom lift up his memory and help me understand the hole that's been left behind by whatever happened. And today isn't the day to say, here's who did what, but it's to think about what's the safest way to ensure that when it's trial time, everyone who needs to be here is going to be here. And between now and then, no one else gets hurt, witnesses aren't influenced, things like that. That's what bond is about. You are welcome to be here every time as well. Hopefully the victim advocate will let you know there'll be times when we meet where there's not a whole lot happening, but we have to have court. You can still come to that, but I don't want you to come and say, why'd you guys drag me down here? Because all you did was pass some papers around. But your presence is important and your words are meaningful. Thank you. Anyone else, Mr. Abadi? All right. Mr. Luemba, you're the movant, so I want to give you the last word. Is there anything more that you want to share with me?
Just kind of piggyback on what Ms. Singleton said. You heard the decisions that this young girl has made her entire life, from pre-K all up to this day. Based on that history, I don't think you wake up in the morning and decide to do something like this, which is why I started off after talking to mom and my limited investigation of this, that, I know Mr. Abadi said that there might have been some laughing on a video or whatever. When people are afraid, they react different ways. And you have all these men and you have this one 16-year-old. That's why I said coercion, intimidation, and duress. And I believe that when all the facts come out, it's going to show that what I just stated, Judge.
Sure.
So I'm asking for a bond, and I don't know if she was indicted when that first bond hearing. I didn't represent her on that.
Okay, that was going to be my next question, because I'm looking at the order. It was pre-indictment. That's why Judge Carnesale had it, but because of the severity of the charge, a magistrate couldn't hear bond.
Right, I understand that.
Yeah, you know the process, but you weren't the one who handled that bond hearing.
Right, and so Mr. Abadi stated, well, what facts have changed since the first bond hearing? The facts have changed is that now she's indicted. That's a big deal. That's a big deal. Now she's indicted. Now the real adversarial process has started, Judge. And I believe that this is somebody based on past behavior of 16 years of life that outweighs something that she has not been found guilty of. And as of now, she's innocent. So she should be given the benefit of the doubt for those 16 years of great decisions that she's made, not based on something that by law, she's 100% innocent of as of today. So we're asking for a $35,000 bond.
Okay. Last question, and it may be one that Ms. Jones needs to answer if you're comfortable having her answer it. I'm trying to figure out why she's at Spalding. And you had mentioned that there may have been concerns for her safety, and that's why she's there. It could just be population management by the jail.
And I don't know, and because I don't know, I wouldn't want her to say that.
Okay, then let's not go there, because there also could be reasons that aren't great that you don't need me to hear, and I'll stay away from that. Okay. Well, this has been helpful to hear from everyone. As with most debates, there's truth on all sides. I have no reason to doubt that Ms. Jones for many years was a model student and maybe member of the community. But we also are now in a situation where for whatever reason, and that reason is actually going to be pretty important in Ms. Jones's case, she got in the mix with people who not once but twice allegedly took the life of another. And what I'm going to do for now, Ms. Jones, is maintain the status quo. In other words, I don't see a basis to overrule Judge Carnesale. I appreciate that one thing that has changed is that you've been indicted, but you were indicted for the things that were the charges you faced when Judge Carnesale heard bond. But there are some things that may change once Mr. Luemba gets discovery, and that's the power of knowledge and information. And so I invite Mr. Luemba, and he knows that's how it operates in my division, that after you get that discovery, Mr. Luemba, if you find that there is evidence that you'd want to point to at a bond renewal or you renew your motion for bond hearing that lends some weight to your theory of the case, that Ms. Jones wasn't a legally voluntary participant in what went on, then we should have that discussion. And I don't ever mean for you to have to disclose your defense or anything like that, but there may well be in discovery pretty clear evidence that there was duress involved. And then that brings us into a different setting. I am confident that there is the evidence that Mr. Abate described. He wouldn't stand up in court and say that, and you'll want to see it. And there may be explanations for it, and there may be a difference between nervous laughter and, hey, this is great that I just was part of this thing with you, Mr. Few and Mr. Bird. And I'm going to await the lawyers having a chance to process that. And then if we need to reconvene to talk about bond, we will. The other reason that we should reconvene, number two, would be if you are encountering delays not of your own making. If you are asking for information and not getting it, if this case is stalled, not because you and Ms. Jones aren't ready, but because Attorney X and her client aren't ready, but we're not severing things out, because that's always one solution, would be to fast track a defendant who's ready. If you're in a ready posture and the case isn't moving, that's another reason to revisit this. And so either one of those is more than enough to file something where then we could engage with the state's argument that, well, what's changed? Because right now, to me, the main thing is that accusations have turned into an indictment. Still not proof, you know that, but that's it. Otherwise, it's the same set of circumstances that got Ms. Jones arrested and named in the indictment as party to the crime of murder. So that's what we're going to do. If you learn there are reasons that we need to relocate Ms. Jones, let me know that, because I can certainly engage with the sheriff's team. But I'm going to assume for now that she's in a safe place for her and the right place for her. And I won't meddle with that unless you bring something to my attention.
Understood, Judge.
Okay. All right. And thank you very much, Deputy Taylor and Deputy Mack, for using your phones and getting Ms. Jones plugged in for this call.